I'm attorney Dedra Sibley. I am of counsel to the law firm of Allen and Arcadier, PA. Today our topic will be driving under the influence. It is not against the law to drink and drive in the state of Florida. However, it is against the law to drive with a blood alcohol level of 0.08 or above. Or it is also against the law to drive to the point that your normal faculties are impaired. That impairment can be by alcohol, a controlled substance, or a chemical substance. If you're out driving and a police officer or law enforcement officer notices irregular driving pattern, quick movements, driving over the line, then he thinks that there may be a case of impairment, the officer will more than likely pull you over. At that time, the officer will approach the car and ask you for your driver's license and registration. Most likely, the officer will also ask you if you've had anything to drink that evening. After making that inquiry, the officer thinks that there may be an indication of impairment. He may ask you to step out of the car and perform what are called field sobriety exercises. At that time, the officer is trying to make an assessment as to your mobility so that he can judge whether or not you are under the influence. Some of the field sobriety exercises are the heel to toe, one leg stand, the alphabet count, usually done in reverse. The officer may also look at your eyes. That is known as the horizontal gaze nystagmus. The officer is trying to look for rapid movement in your eye pupils, which is sometimes just one of the indicators of your alcohol level being in abundance. If after the field sobriety exercises, the officer believes that there is impairment or needs more information, he will most likely ask you to consent to a breath test. Now, that breath test may be used if in the future there tends to be a trial. You may refuse a breath test. However, in Florida, we have something that is called implied consent. Implied consent means that when you sign for your driver's license, you acknowledge that you will provide a breath test when asked. If you refuse the breath test, upon the first refusal, your license will be suspended by the Department of Motor Vehicles for 1 year. This is not a suspension by the court of law. This is by the Department of Motor Vehicles. If you refuse a breath test for a second time or more, it does become a criminal offense. At that point, your license will be suspended by DMV for 18 months. If you do take the breath test and you blow over 0.08, then your license will also be suspended by the Department of Motor Vehicle for a 6-month period of time. After the field sobriety exercises, the breath test, the officer's observations as to your movements and what they are looking at your normal faculties, the officer may determine that he has probable cause to make an arrest for driving under the influence. At that time, you will be transported to booking, and you will be booked and charged with the driving under the influence. It is imperative that you get a lawyer involved as soon as possible in this process. It is also imperative that you seek out an attorney who has experience in defending driving under the influence cases.